One court which is lying in Mrs. Lordship kindly ask the court officer to bring the court in this court and Lordship the matter is scheduled to be taken on 7th August.
7th of
7th August.
7th August.
7th. And Lordship kindly tag.
Now, what is the FMA number?
FMA number Lordship 1088 of 2010.
Today's item.
Today's item. Item number 11 Lordship.
Item number 11. So you are for the
I'm for the respondent claimants.
respondent claimant. You filed on court.
Yes, sir.
So where the court is?
Desert section. Yes, sir.
Okay, call the court. So the court has to be listed. Otherwise, how can it be disposed of? That cannot be taken like that.
That's why I find that she is mentioning the court.
Yes, court has to be listed first. Thereafter, the matter can be heard. So,
the matter is whether was due taken up by your lordship on Monday. If the lordship court officer sent the requisition, the court is
okay, give me the requisition.
Application. May I be permitted to mention one application option?
Yes.
Your Lordship, one matter, Lordship. In this matter, Lordship, the order in respect of this matter was passed on the last month, Lordship, but Lordship, the order has not been uploaded in the service.
Order is not uploaded. What is the order? What is the number?
FMAT, Lordship, 1182 of 2014.
FMAT?
19th of July, Lordship, that order was passed.
19th of July, the order was passed.
Lordship.
It was not uploaded.
Lordship.
May I participate?
Yes.
I have filed a petition for approval. Order filed the 2nd August and copy search.
These are the old appeals. Yes.
Yes, Lord. Let me hear the correction in the call title proportion, Lordship. Actually, it will be NF Railway, but it was written as the Eastern Railway, Lordship. I have corrected earlier, Lordship, after getting leave from the court.
So this is appear for correction.
Yes, Lordship.
Correction of what?
Cause title portion, Lordship. Cause title portion.
Cause title of
Union of Railway. It is written as Eastern Railway. It
cause
will
title of what? Memo of appeal.
Memo of appeal, Lordship. The memo of appeal, Lordship, I have corrected after getting leave from court. But in the order sheet, Lordship, it was written as Eastern Railway. It have NF Railway.
Eastern Railway.
It will be NF Railway.
First call title.
First page.
Bottom first page.
Yes, Lordship. Bottom.
First page in the certified copy.
Yes, Lordship. Yes, Lordship.
Not in the order itself.
No, order person okay, Lordship. Order person.
Name.
Order person name to
Appellant.
or appellant name.
Appellant name will be correct. Appellant.
Yes. What is the name of the appellant?
Supradim Dhora and Kazi Abraham.
Learned advocate appearing.
Yes, Lordship.
The name of the advocate has to be corrected.
Two correction, Lordship. Number one, Lordship, in the cause title, it was typed as Eastern Railway. It will be NF Railway.
So you have got certificate copy. There is mistake in the certificate copy. How can it be corrected by the court? You go to the department. If there is an error in the order, that can be corrected, you know. But the certified copy has given you wrong name. Already you have corrected by the order of this court. The memo has been corrected already by the order of this court.
Yes, Lordship.
So this is the part of the department you have to ask for. not for the
Lordship.
court.
Lordship, Lordship.
This is the first page is for
Yes,
certificate.
Lordship, Lordship. Sorry, Lordship.
You understand the issue?
Yes, Lordship, 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 Lordship.
You just ask for them, otherwise I can pass an order.
Lordship, Lordship.
The
Lordship.
department has
Yes, Lordship, I have
not
understand.
corrected the same. Okay.
Naam ta change.
And the name of the appellant.
Appellant.
Appellant name. Name of the appellant.
It will be Supratim Dhar and Kazi M. Rahman.
Learned advocate appellant.
Yeah, advocate, Lordship.
Appellant.
Advocate, appellant's advocate.
Appellant's name is Agnu Orav.
No, name of the advocate, Lordship, for appellant.
The order. First.
Order. It is for the appellant is Sanjoy Pal.
Yes, Lordship. It will be Kazi M. Rahman and Mr. Supratim Dhar.
And your name is correct?
Our name is correct.
Your name is correct.
Lordship.
Your name is Pradeep Kumar Das is there.
Lordship.
So this correction. This matter appear for correction in order dated 7/7/2023. The name of the learned advocate appearing on behalf of the appellant should be read as instead of Mr. Sanjay Pal. Let the instant order be a part of the judgment dated 7/7/2023.
Lordship, Lordship, Lordship. Fight it, I will fight it.
Next,
Lordship, I am appealing on behalf of respondent insurance.
yes, appearing for correction. Affirmative.
My lord, I'm appearing for the petitioner, my lord, led by Uday Shankar
Yes,
Chatterjee.
yes, what is your submission?
Lordship, it has come up for some correction. It's written in the list, Lordship.
Do you know what you require the correction?
No,
What
my lord, this
correction
is
you
for
require?
hearing. This
No,
is for
today is
hearing
not for
matter.
hearing, not for hearing. Please take down. The instant matter appear for correction. It appears that the number of the appeal was wrongly written in the order dated 12th of July 2023 as FMA 387 of 2013. It should be read as FMAT 387 of 2013.
Lordship, will take it up on Monday, Lordship. I have
As you
received,
wish.
I have received the paper.
Here is the paper book.
If
So
my lord-
whether appellant is ready?
I believe if the paper book is ready, and my learned friend has also handed over a copy to me.
Very well.
My lord so desires, my lord may take it on.
So what is the submission of the appellant?
My lord, if my lord wishes, my senior will appear today at 12.
No, no. What is your instruction now? You don't have
No,
any instruction?
No,
Okay. Very well. Let it appear accordingly. LCR is not there along with this record.
I'm making the
Yes. Yes. What is for mentioning?
Malad, this matter has been mentioned. Malad, this matter has been settled out of court. Malad, the first appeal is Malad of the insurance company. The second is Malad the cross appeal. Two appeals are there, my lord.
But I'm maintaining for settlement.
The learned friend mentioned the matter since it has been settled out of court. Well, this is the, my lord, approval letter. My lord.
So both of you don't want to proceed further.
Yes, ma'am.
So what is about the deposit?
Deposit, my lord, the company has deposited the statutory deposit of 25,000. But it was deposited in the year 2019. And my lord, in terms of the my lord, order dated 8 July 2022.
Yes.
My lord, we have deposited 5,28,200.
That means entire ordered amount has been
Yes.
deposited.
With the after calculation of the interest.
Okay, please take down.
And the matter has been settled, my lord, at rupees 4,34,000.
Whatever maybe it was settled.
Yes.
I am taking this document.
Yes. Everything has been written, my lord.
Okay.
Only, my lord, the date of deposition of the, my lord, the awarded sum, the date should be, my lord, 4th August, not 3rd August. That is, my lord, wrong.
So what is your settlement? You want to hand over the entire amount directly or to receive from the court? From the
Register General.
yes, Register General.
From the Register General.
They are accruing interest. They have to be.
My lord, I'm 4 lakhs 34,000 will pay to the respondent. That's mean my client, that claimant will be disbursed by the Register General, and balance amount along with interest should be disbursed in the name of insurance company.
Since, my lord, we have the money is lying with the register.
And
So, this is the settlement.
Yes.
This is within the settlement.
Settled amount is, my lord, 4,34,000.
34,000.
Very well, very
My
well.
lord, let that amount be handed over to the, my lord, the respondent.
And the balance amount to be refunded.
Balance amount to be refunded with my lord, accrued interest.
Yes. Please take down. Both the appellant and respondent, including the claimant, that is the applicant of court 84 of 2019 appeared. It is submitted by both the parties that the matter was settled out of court, and on the basis of said settlement, they agreed to each other that the full and final settlement amount rupees 4,34,000 is to be the compensation amount of this case, and that has to be handed over to the claimant. Stop. So both the parties appeared before this court so that both the matter may be disposed of in terms of the settlement. Stop. The copy of the settlement arrived at between the parties is taken on record. It appears that the matter was settled outside the court. Thus, there is no legal impediment to dispose of the instant appeals along with the court. Hence, it is ordered that the instant appeal being FMA number 930 of 2022, along with court 84 of 2019, is disposed of in terms of settlement arrived at between the parties outside the court on 27th.
That is the communication
Non-necessary.
instruction.
Okay. Arrived at between the parties. Stop. The claimant.
Yes.
That the claimants. Yes, the claimants are at liberty. No, stop. The insurance company has already deposited the amount of rupees 25,000
Statutory duty.
as statutory deposit. White challan number 2578 dated 15/1/2019 and rupees 5,28,245 white challan number 1448 of 48 dated 8, is dated 3rd of August, 4th August.
Yes,
4th August 2008,
but challan number
4th
1.
August 2022. 22. I challan number 1448 dated 4th August 2020.
But the previous challan 25,000 challan is 2578 dated my lord 15th.
Yes, noted. Stop. Already deposited that amount. Stop. The deposited amount obviously has accrued some interest and lying with the concerned bank. Stop. Considering the facts and circumstances of this case and considering the terms of settlement, the claimant are at liberty to receive the amount of rupees 4,34,000 from the office of the London Registrar General, High Court, Calcutta. The rest deposited amount along with the accrued interest shall be refunded to the insurance company on the basis of requisite prayers. You have to make a prayer there.
My lord, kindly direct the registrar general because my lord liberty my lord they made. Kindly pass a direction upon the registrar.
Registrar General to bola.
Your lordship has said that claimants are at liberty.
At liberty. Okay. So, for the compliance of the above order, London Registrar General is hereby directed to do the needful so that the amount as deposited by the insurance company may be disbursed according to the direction made above.
Great.
As early as possible.
Great.
Both FMAT, FMA,
Instruction
FMA
should be
930 of 2020 and court 84 of 1990. Disposed of.
My lord, both the appeals along with all other applications. Connected applications.
Connected application.
And your lordship has kept
on record, my lord.
Yes, it
yes.
will be kept on.
kept on. এই তোমার কোর্টে আমি grateful, extremely grateful.
May it please your lordships. No,
Yes, for the claimant,
my lord, respondent claimant.
respondent.
Respondent claimant. My lord, the claim case has been filed, instituted for paying for compensation, just compensation. My lord, on account of injury, permanent disability, which was caused by the offending vehicle.
Yes,
And my lord, at the time of accident, the monthly income of the victim injured was rupees 1,15,000, which he used to get while he was at Singapore. One of the certificate, one of the income tax return, which was filed therein, that has been filed. It has been stated in the affidavit of examination chief, that is within the LCR. LCR ta, ekটু LCR ta দিয়ে দেবেন just.
whether it was exhibited,
No, that has not been
Why
exhibited.
not?
My lord, this is the procedural latches. For that reason, my lord, claimants should not be suffered in, my lord, since there is, my lord, statement has been made and the landed tribunal below, while assessing the compensation amount, this amount has been taken care of. Bimla Devi, the Honorable Appeals Court, I shall come. Bimla Devi, it has been stated, when the document has been produced and the statement has been made in the
In Bimla Devi, the
Yeah.
medical documents, medical vouchers are taken into account.
No, my lord, entire thing has been taken into
No,
account.
medical voucher, go to the Bimla
My
Devi.
lord, I shall come.
Only medical documents are there, which was not considered, but the
My lord, the
medical.
main question,
No, I
question,
want to know why you not exhibited the documents.
my lord, that has not been exhibited by
So
the,
how can I peruse the?
my lord,
without
that can
LCR?
be, my lord, I shall come, that can be, my lord. Since, my lord, the landed tribunal below accepted the, my lord, this is income tax return filed at Singapore.
So this is why you not
My lord,
exhibited it.
from Singapore, my lord, this document, the foreign,
What are my foreign documents? What is your bar to prove the
my
foreign
lord,
document
it
here?
is not possible, it is not possible from Singapore to come and,
Not necessary to Singapore to come.
My lord,
There are other scope.
my lord, one minute. My lord.
হ্যাঁ।
আমাকে
সিঙ্গাপুর এমবেসি আছে না
Okay. Certificate for-
সার্টিফাই করা
Yes. My lord, this certificate has been done by the embassy.
Then why you not prove it as secondary evidence?
But secondary,
Secondary evidence?
my lord, I
Not
am coming.
necessary to prove primary evidence.
My lord,
You may prove it on secondary evidence.
my lord,
Now in
That-
the appeal, if I go to concentrate over that, there would be an objection. Not exhibited,
no, no,
not.
that has been taken by the tribunal below. My lord, that
That is-
amount has been taken
That's
by the
why the
tribunal.
appeal has been preferred.
My lord,
That is the ground of the appeal.
my lord, that
You have to.
Bimla
cross
Devi,
this
my lord,
hurdle
I am
first.
coming. Bimla Devi, I am coming.
No, you have to cross this hurdle first. You know.
Yes, yes, my lord.
Yes. You just cross this hurdle. What was your evidence and what is the cross to that effect?
Yes, cross.
Come to the evidence first.
Yes, yes. My lord,
PW1.
PW1, my lord. I used to start from, my lord, contributory negligence for that reason, my lord. At first, my lord, kindly see.
You first come to the
Yes, my lord, evidence,
evidence part
evidence.
regarding the income.
Regarding the income. At first, my lord, kindly see page paragraph, my lord, page 14. Page 14, paragraph, my lord, 8. That at the material time of the accident, I was aged about 39 years and I was an employee of Metals Online PTE Limited situated at Singapore and used to earn 4450 Singapore dollars gross such and such, and my lord, Indian currency such and such. I used to pay income tax regularly at Singapore on the above salary. I was an active and healthy person and was the only earning member of my family consisting of my wife and 2 daughters. I used to travel very frequently on the business, visited to various countries including USA, as I have restricted movements due to damage such and such business, various countries, USA, I have restricted movements due to damage of my right leg, and in spite of my best efforts, I could not perform such and such. Thereafter, my lord, that line, that when I started working in India, my salary was 35,600. My lord, that has been reduced. After 5 or 6 months, he joined the, my lord, job. And thereafter, if I would have been working in Singapore, my current income would have been around 7,500 Singapore dollars per month. My lord, thereafter, 10, that since I am mentally normal and with my work experience, I am in service which involves desk works only. Now I am earning 61,000 approx. My lord, then kindly see cross examination. Regarding the income, there is no suggestion at all in the cross examination. My lord, kindly see the cross examination, page 17.
Yes.
Page 17, my lord. My lord, from top, my lord, 4 lines, I felt okay, so I joined. My physiotherapy was going on. I was not moving freely. Not a fact. I deposed falsely. It is a fact. I boarded one step on the dock now. At the time of accident, I was going in bus towards Lake Town. When I was getting down from the bus, the accident occurred. The accident occurred as while I was about to get down, the bus was moving. My lord, here, the bus was started moving. My lord, it will be treated as passively. I bought ticket of the bus. I submitted the ticket of to my such and such when this FIR was filed. At first, I was taken to Arjikor medical. I was there for 1 day, and from the Arjikor medical I was at the Princess Nursing Home, and next day I was shifted to Bellevue Nursing Home, and my surgery was done at the nursing home. There was admitted for 12 days, and I was discharged with advice for bed rest for 3 months for physiotherapy. Thereafter, I had to continue physiotherapy for another 2 months, and then I went to Singapore. I am working now in Jaipur for a salary rupees 60,000 per month. I am working regularly. My nature of job has same. Earlier, I was frequently traveling for international marketing from Singapore to Europe, USA, etc. Now I do only office work. My passport will show such report. My lord, regarding the income of the
Come on,
Singapore.
Next page.
Next page, my lord, kindly see.
After 3 line.
I went to BNBOS Hospital, Barracoon. I came to know from Arjikor Medical Hospital, I need to visit that place for certificate. It is fact that I was not treated as SD BNBOS Hospital. Now, not a fact that I deposed falsely about my income prior to the accident. Not a fact. I am completely fit. Not a fact. Well,
Yes,
this is all.
Your income was challenged.
My lord.
Your income was challenged by cross
Not
examination.
a fact. My lord, the question specifically has not been put.
What question? You are not earning such rupees.
My lord, and you have not produced. You have not paid any income tax.
You have not produced a single document of your income.
My lord,
Regarding 60,000 also no document. Regarding 1,50,000 no document.
my lord, document has been produced. My lord, the income tax return has been produced, and from embassy, my lord, it has been. My lord, the LCR will shows it. And my lord, in this
So
regard,
you can prefer before the come on exhibited and come here again.
my lord, here.
If you
My lord,
are-
kindly see
if you
Bimla
want to
Devi. What
proceed
Bimla
like-
Devi said so. What Bimla Devi said so, my lord. Bimla Devi. ওই যেটা দেখি ওটা ওষুধে আছে ওটা দেখি এটা না Bimla Devi। কেন বলবো না স্যার Bimla Devi আপনি জানেন এই তো দেখে
সব কথা তো সবসময় আমি জানি তাহলে তুই বল না
এই তো দেখুন তো এই তো দেখি এটা
Yes, what is the para you are referring?
my lord, my lord, 25 onwards.
25.
Yes. Keeping in view the aforementioned principles of law, when we examine the facts of the case at hand, we are of the considered opinion that the claims tribunal and the High Court were not justified in dismissing the appellant's claim petition. In our view, the appellant's claim petition ought to have been allowed for awarding reasonable compensation to the appellants in accordance with law. This we say for the following reasons. First, the appellant has to adduce sufficient evidence to prove the accident and the rash and negligent driving of the driver of the offending vehicle, which resulted in death of Rajendra Prasad. Secondly, the appellants filed materials document to prove the factum of the accident and persons involved therein. Third, the documents clearly establish the identity of truck involved in the accident, the identity of the driver of the truck, the identity of the owner of the truck, the name of the insurer of the offending truck, the period of coverage of insurance of truck, the details of the lodging FIR in the concerned police station in relation to the accident. In our view, what more document could be filed than the documents filed by the appellants to prove the factor of the accident and the persons involved therein? Fourth, so far as the driver and owner of the truck were concerned, both remained expertise since inception, and therefore neither contested the appellants nor claim petition, nor entered into the witness box to rebut the allegation of the appellants made in the claim petition and the evidence. An adverse inference against both could be drawn. Fifth, so far as the insurance company is concerned, they also did not examine any witness to rebut the appellant's evidence. The insurance company could have adduced evidence by examining the driver of the offending truck as their witness, but it was not done. Sixth, on the other hand, the appellants examined 3 witnesses and thereby discharged their initial burden to prove the case. 7, if the court did not exhibit the document despite the appellants referring them at the time of recording evidence, then in such event the appellants cannot be denied of their right to claim of compensation on such ground. In our opinion, kindly see 33. This is, in our opinion, it nothing but a procedural lapse which could be made basis to reject the claim.
Have you referred your documents?
My lord, that
Have
has
you-
been recorded, my lord, in the claim, my lord.
No, you have not referred it.
No,
You
where?
have already mentioned it. Referring is separate thing. This is the tender.
My lord, reference means, my lord, the income has been referred in the claim petition. My lord,
The document has to be referred. This is the view.
my lord,
document
yes,
despite
document has been referred. My lord, kindly see paragraph 12 of the, my lord, page 15, page 15, page 15, my lord.
I have already got.
Yes. My lord, page 15, it has been stated, my lord, income has been stated, and my lord, here, page 15, statement of Provident Fund, Singapore indicating the contribution towards Provident Fund by materials such and such, income tax return, entire thing has been, my lord, stated, and that has been produced before the tribunal. And after considering that, my lord, while tribunal, my lord, assessing the, my lord, compensation, my lord,
That's an error. That's an error.
my lord, error is there. Yeah, error is also there. My lord, while tribunal assessing the compensation at the time of income of the victim has not been taken place, the differential amount has been taken into consideration. Your lordship knows the Ajay Kumar, and several decisions are there where, my lord, at the time of accident, which was income, after multiplying the same, the percentage of disability.
If you not prove any document, not tender any document.
But
there is
tender, that document has been
no-
tendered.
No, that was not tender. This is not tendering.
My lord,
You are stating some exhibited document that they are, this is my document. That is not
my
sufficient for
lord,
tendering.
kindly see the Firisti. Kindly see the
I
Firisti.
have seen your the deposition. In the last page, there are some list of documents.
List of documents has been given.
But you have not tendered those documents. That is, this is my document.
This is my document, my lord, that has not
So
been
that,
recorded.
so that
That
there
has not-
there's such
your
a
lordship
chance
knows-
of examination.
Your lordship knows the practice of that.
No, practice is not taken to be care of. Here taken to be care of the law. What is the law?
My lord, law is there.
Dictation is here, document has to be referred.
Document has been filed. That has been, my lord, filed. And,
Filing is not referring.
my lord, at the time of filing, tendering the affidavit of the examination chief, that has been tendered. My lord, kindly see. Kindly see, that has been tendered. My lord, here, your lordship will find page. I have filed one affidavit in chief. This is my affidavit in chief. I filed certified copy of FIR charges such and such, my lord, etc. has been given. My lord, I have filed affidavit in chief. That means, my lord, the entire affidavit in chief has been tendered.
Then Why you stated like that? I have filed certified copy of
That has been
FIR,
recorded.
charge
That has been
sheet.
recorded.
This is the tendering.
That has been recorded. I have
This is
filed
the
this.
tendering.
This is
What
my
you
this is
tender?
my affidavit in chief.
Yes,
This is my affidavit in chief.
yes.
With the affidavit in chief, entire thing has been given. Entire thing has been
No,
given.
no, read thereafter. Why this is the procedure
I
followed?
have filed other documents.
Yes.
I have
What are
filed
the
other
document you
documents
tendering
of
in this
injury
case?
and income. I have filed other documents of injury and income. Kindly see the last line.
Yes.
Kindly see the last line of that page, page 16. I have filed other documents of injury and income. So it will not become within this periphery.
Very well. Anything?
My lord, regarding income, and I am coming one after another, my lord.
Bhimla Devi.
First, they raised the issue regarding contributory negligence.
So regarding income, this is your submission.
Regarding income, this is my submission.
Very.
আপনি জানেন, sir?
Yes. Next.
Page 3. That on 16th January, page 3, para 23.
Yes.
That on 16 January 2001, at about 13:45 hours, the offending vehicle bearing number such and such, which was proceedings along Jessard Road with a terrific high speed in a most rash and negligent manner, endangering human life and safety to others, thereby disobeying and violating all traffic rules and regulations. When the said offending vehicle came near Amrapalli bus stand, the said bus just stopped. But at the very certain moment, the said bus again started without any ring or information.
What are you
When-
reading?
My lord,
Offending bus was accelerate.
yes, my lord.
Page 13.
Page 3.
Page 3.
Page 3, my lord. This claim petition, my
Oh,
lord.
claim petition you are reading.
Yes, my lord. This case of the, my lord, claimant,
Yes, yes.
regarding rash and negligent driving. My lord, 23, it has been stated, the bus stopped. My lord, kindly see page 23,
Para 23.
para 23, page 3, that, my lord, starting from the word that on 26 January 2001, at about 13:45, my lord, got it?
Yes.
Got it hours. The offending vehicle bearing number WBS such and such, which was proceedings along Jessard Road with a terrific high speed in a most rash and negligent manner, endangering human life and safety to others, thereby disobeying and violating all traffic rules and regulations. And when the said offending vehicle came near Amrapalli bus stand, the said bus just stopped. But at the very certain moment, the said bus again started without any ring or information, when the victim Suresh Sharma getting down from the bus, as a result of which the victim fell down on the road and the ran over by the wheel of the said bus and got severe injuries on his person. My lord, this is the fact. This is the fact. My lord, in this case, your lordship will find, my lord, in the cross-examination, the insurance company advanced before the argument. My lord, kindly see page 17 here, cross-examination, my lord, from top 1, 2, 10. My lord, 10 lines, from top 10 lines, 17. My lord, here the accident occurred while I was about to get down, the bus was moving. My lord, here the bus started moving. My lord, that will be passively, it will be treated.
What?
My lord, the accident occurred while I was, my lord, got it. My lord, here,
Page 17.
page 17, my lord, from top 10 lines.
When I was getting down from the bus,
Getting down, the bus was moving. My lord, here in recording, bus was started moving. Passively, it will be treated. My lord, the insurance company several times, my lord, argued before your lordship, advanced the argument that the victim himself was contributed to the negligence.
the accidents occurred as while I was about to get down.
About to get down,
The bus.
the bus started moving. Bus was started moving.
Where is the start?
My lord,
What?
start will be passively it will be. Because my lord, my claim petition is something. And at the time of recording, my lord, it will be passively.
And
Passively it will be treated.
why you stated in the chief that bus was moving? The cross
In
is
the-
on the behalf of the chief, on against the chief.
Yes, my lord, kindly see.
Paragraph 2, page 13.
Paragraph 2. Paragraph 2, my lord. Paragraph 2 is there.
Yes.
And in this case, your lordship knows the principles of res ipsa liquidator and the my lord, in a similar situation, our High Court, my lord, kindly see this. Your lordship will find case of Hon'ble Valmiki. My lord, it has been decided on 22nd August 2022, where Mr. Bonik appeared before this honorable court. My lord, paragraph 12.
Not been judgment cited again, not knowledge.
রিপোর্ট হয়নি স্যার, না রিপোর্ট হয়নি।
আমার judgment report হয় না।
Paragraph 12.
Paragraph 12, my lord, this is the my lord, the case of the claimant is paragraph 3. Case of the claimant is paragraph 3. My lord, paragraph 3 on, my lord, kindly see, on 22nd November 2006 at about 11:30 p.m. Rajesh Valmiki, son of such and such, was trying to get down from the first gate of the bus bearing registration number such and such at Dattobagan crossing. Bus stoppage on
The bus stopped.
bus stoppage on Belgachia Road. The bus
No, the
stopped
bus stopped at the
at
said
the
bus
bus
stop.
stoppage coming from western side to eastern side along Belgachia Road. At that time, the driver of the bus started driving the bus with a high speed. My case is also same, but it was the accident happened near Amroballi bus stoppage.
No. Here is the specific case. The bus was stopped at the bus stoppage.
My lord,
But the question raised that the bus in your case was not stopped,
my lord, stop.
but you get down from the bus.
No.
Hurried.
It was stopped. It was stopped. My bus stop. My claim application also in this case, but bus
Your
started
claim
moving.
application stated the bus was stopped, but your chief and the cross examination is
In the
not
cross
stated.
examination, bus was moving. It has been stated. My lord, bus was moving. Bus was get down. Bus was moving. My lord, what will be the meaning?
Meaning is very clear.
Bus was stopped. Passively, it will be, my lord, started. Passively, my lord, started has been left out in recording. My lord, your lordship knows that. And here, the res ipsa liquidator, principle of res ipsa liquidator, my lord, kindly see. Page, paragraph. In this case, my lord, Hon'ble Valmiki,
Yes.
paragraph 21. And in the instant case in hand, which is going on before your lordship, the insurance company has not adduced any evidence. The driver has not come. The Mita Samanta, your lordship knows that. In Bhimla Devi also taken care of that fact also. (23) main fact. 23 has been in favor of the claimants has been given. And your lordship knows the Mita Samanta. Mita Samanta, your lordship knows. Again, I am only referring to this. Only for the same fact. Mita Samanta, sir, this is, my lord, my submission is regarding contributory negligence.
What is your submission regarding contributory
My lord,
negligence?
contributory negligence, the bus itself was.
That means what is your submission? There is
My
no
lord,
contributory negligence.
this submission, the landed court below held in favor of the claimant that the driver of the bus was negligent. That has been held by the tribunal below. Thereafter, my lord, income and contributory negligence has been submitted. My lord, then, my lord, your losses will find from the medical expenses. The medical expenses on the earlier occasion, the insurance company advanced before your lordship that the sum of the income is not with the relating to the treatment. My lord, medical expenses is from, my lord, page 60 onwards. Some of the expenses, such as, my lord, the income which has been shown regarding SAVE, my lord, page 63. Page 63, my lord, the charges of saving has been advanced before your lordship. My lord, the Rajkumar Ajay Kumar, your lordship has several times, my lord, have seen in paragraph 5 of Rajkumar Ajay Kumar. In paragraph 5 of Rajkumar Ajay Kumar, the heads under which compensation is awarded in personal injury cases are as follows. My lord, pecuniary damage, special damage, the expenses relating to treatment, hospitalization, medicines, transportation, nursing of foods, and miscellaneous expenditure. Whether it will not be coming within the periphery or ambit of pecuniary damages.
Rajkumar and Ajay Kumar. Rajkumar versus Ajay Kumar was referred
Yes.
to show the principle of functional disability.
No, not. This is not to the extent functional disability.
No, it was argued and advanced.
They argue.
Yes.
They argue. But my lord, I am arguing. My lord, they stated that the other only expenditure relating to treatment is 20,000 only. But my client has paid 40,000 odd. That has been exhibited. The hospital came and proved that document. The other charges bed charges, etc. Only they confined to the argument only medicines only. In Rajkumar or Jai Kumar, how a case has to be dealt with in assessing just compensation, entire thing has been given. But in the Rajkumar or Jai Kumar, the future prospect, whether in assessing compensation in a case of a injury, whether future prospect has to be added or not, that has not been dealt with. Afterwards, after 2013, for Sanjay Verma's case, first time, my lord, after considering the decisions of the Honorable Appeals Court, Rajesh versus Rajvi, my lord, future prospect has been added. Thereafter, in every cases, your lordship, I am coming, your lordship will find, while assessing compensation in an injury case, the future prospect has been added in assessing just compensation. And here, your lordship will find the page paragraph 5, my lord, two aspects are there: pecuniary damage, non-pecuniary damage.
Yes.
In pecuniary damage, which will come? My lord, expenses relating to treatment, hospitalization, medicine, transportation, nursing of food, and miscellaneous expenditure. Loss of earning and other gains which is injured would have made had he not been injured comparison. Loss of earning during the period of treatment. Loss of future earnings on account of permanent disability, future medical expenses, and non-pecuniary damage, general damages for pain and sufferings, and trauma as a consequence of the injuries, loss of amenities, and loss of experiences of life, etc. These heads has to be taken into consideration in assessing just compensation. My lord, here your lordship will find, while the victim was admitted in the hospital, that amount has been incurred by him, and that has been, my lord, disbursed by the tribunal below. My lord, at the time of assessing compensation, my lord, tribunal below, we kindly see, my lord, page 29 of the paper book. My lord, I am placing. So far as deciding on quantum of loss of income suffered is concerned, in his examination chief, PW1 deposed that he was getting salary rupees 1,15,700 per month at the time of accident, and after 6 months of accident, when he got a desk job at Jaipur, he started with his salary 35,600. My lord, that has been reduced from 1,15,000 to 35,600 within a period of 6 months. So, as per him, he suffered loss of income such and such, 80,100. Thereafter, learned counsel for the claimant argued that as per the claimant, his present salary is rupees 60,000, and this fact is corroborated in positive during his cross-examination. Reversely, it is nowhere denied that this started with a salary rupees 65,600 per month in Jaipur, where he joined long after the accident. So there is no reasons not to believe him about his loss of earning. Learned counsel further argued that the percentage of permanent disability must be assessed with the reference to the loss of income, as to the term disablement means loss of impairment of the earning power, not to mean loss of member of a body. So thereafter, 45% disability has been factored. Such as the learned counsel for the claimant argued that there is no positive evidence adduced by OP number 2 to all disprove the statement of claimant as regards his income, loss of income, or negligence of driver. Learned counsel for the OP number 2 is additional written argument submitted that claimant had no such huge income. That is why he has not produced any income tax document. My lord, kindly see. The learned counsel for the claimant argued that claimant has proved his PAN card such and such. He also the opportunity to disprove the income by calling for relevant records, but he never did so, as that would have not helped his case. Learned counsel argued such conduct on the part of the OP. Number 2 may also release us to adverse presumption. Learned counsel argued that he was earning rupees 1,15,000 per month at the time of accident, and his earning was reduced after 6 months. He joined at Jaipur, salary was rupees 35,600. So he suffered loss of income to the tune of 80,000 per month. Thereafter, my lord, your lordships will find, my lord, that is the, my lord, thereafter, my lord.
There is the lapse.
My lord,
There is the lapse in the judgment.
yes.
Why he believe your statement without any document?
My lord,
Learned tribunal?
document is there. Document, no.
Whether there is any reference
My lord, reference, my lord, in the
in the judgment, whether there is any reference
income.
in the judgment, whether there is any reference that this document contains the income of the claimant to be 1,15,000, and this document refers to the income of
My lord,
35,000
that
first.
document refers in my affidavit in chief. at the time
Whether
of
that is
tender.
mentioned in the judgment.
My lord, your lordships, my lord, sitting at first appellate court, your lordships has power enough.
Yes, I can reverse back. I can reverse back. It would be
My lord,
better for you.
that is,
Reverse back. Otherwise, I can pass the order
my lord,
if you want to proceed further.
my lord, I shall have to.
No, it was positive argument was made by the insurance company that was denied. Positive argument
My
was
lord,
made regarding the income.
First of all, your lordships has put a question upon the claimant that whether that was tendered or not. Your lords, I have shown before your lordship that was tendered. That was tendered. That was tendered.
Not exhibited. No
Exhibited.
document.
That is the, for that is in my lord Bhimla Devi. For that is in Bhimla Devi stated so. For that is, this is, my lord, this is.
Bhimla Devi stated to be tendering of a document, particular document, the such huge income is
My lord,
stated.
the other.
Why you keep mom there? Why you keep yourself mom there?
No,
Regarding your income.
Initial burden has been discharged by me.
Why? How?
My lord, the producing,
And you have not looked that the document was not exhibited and proceeded. And the argument was made to that effect.
The argument has been made.
Yes, by the insurance company.
My lord,
there is no document, specific argument is there.
My lord, the document is there in the record. Materials of document is in the record. It is not the case.
Whether it is stated like that in the judgment, the materials of document
My lord, judgment has not been stated, but your lordships can, after considering the Bhimla Devi's case, your lordships can. Your lordship is sitting first appellate court. First appellate court has got power, many power, including fact as well as law.
That would be, it is necessary for the remand.
My lord, thereafter, my lord, kindly see disability certificate, my lord, here. The disability certificate issued by government hospital and private doctor shows that 45% disability with multiple fracture on leg. Under such facts and, my lord, bottom portion. Under such facts and circumstances, claimant found entitled to receive compensation in view of materials and evidence on record. The loss of income of claimant is taken 50,000 per month in view of age of victim. As per PAN card, such and such, 50,000. My lord, 50,000. Where from 50,000 got it? My lord, that is the differential amount. That is the differential amount. Differential amount, my lord. Now
what from what difference?
My lord, 1,50,000, 15,000 minus 61,000. About 50,000 has been taken.
What about 50,000?
My lord, kindly see here.
That is more than 80,000. Why 50,000 was taken?
More than 80,000 since, my lord, at the thereafter income has been increased to the tune of 61,000.
Whether that was mentioned.
That has been, my lord, at the time of cross examination, that has been dealt with by the tribunal. At the time of cross examination, my lord, the question put and admitted.
All on the basis of presumptions. No document of recent income.
Actually, the tribunal below calculated the compensation on the differential amount. My lord, actually, your lordship knows in several days I am coming, my lord. The income which was at the time of accident. After that, multiplier method has to be applied by adding future prospect relating to age. by following Konoisetti. Konoisetti has come 2017. And here, my lord, kindly see the calculation 50,000 multiplied by 12, my lord, yearly income has come 6 lakhs. Page 30, my lord, bottom portion. Yearly income has come 6 lakhs. $50,000 is to be deducted towards income tax. My lord, 5,50,000 has come. 10%, my lord. Thereafter 5,50,000 into 16, my lord, that is the multiplier. 16 is the multiplier. 88 lakhs has come. Disability to that extent, my lord, 45% has been calculated on that amount.
Yes.
This is the calculation. This is the calculation. Actually, income has been taken 50,000, my lord.
Yes.
My lord, in a case, my lord, personal disability to the extent of 45% in 2000, 2022 for TSC 731 SC. By TSC 731 SC. Horium. Here, your losses will find paragraph 3, how a calculation has been made. Paragraph 3. The appellant has suffered multiple fracture and dislocation of the left elbow, nailing of right tibia and femur bone. The appellant undergone several surgical procedures, including reconstruction of right elbow. The board doctor assessed the permanent disability to the extent of 45%. The tribunal, while taking into consideration the emoluments of the appellant as rupees 18,941 per month, applied the multiplier 16, keeping in view the age of the appellant was 32 years. Thus, the total compensation rupees 21,94,080 was awarded, including expenses towards physiotherapy, special diet, convention, earnings such and such, and future medical expenses such and such, was on account of loss of future income due to disability. The High Court, in an appeal filed, the insurance company reduced the amount compensated by applying multiplier 9 for the reasons that there is no loss of employment. We have heard learned counsel for the parties and find that the High Court has erred in law in reducing the amount of compensation. The appellant, though continuous be in service, but his efficiency as a constable has been seriously compromised. Therefore, the amount of compensation awarded by the Motor Accident Claims Tribunal, rupees such and such, was just and proper, keeping in view of injuries, its long-term effect on the person of the appellant. One the income which was there at the time of accident, that income has to be taken into consideration. But the landed tribunal below, differential amount has been taken. In Kajol, this is 2020 reported in SAR Civil 2020 SAR Civil 530 Kajol versus Jagdish Chand. In Kajol, your lordships will find. In Kajol, my lord, paragraph 20, loss of earning. How a calculation has to be made.
Yes.
My lord, paragraph 20, my lord, kindly see. Both the courts below have held that since the girl was a young child of 12 years, only notional income of rupees 15,000 per annum can be taken into consideration. We do not think this is the proper way of assessing the future loss of income. This young girl, after studying, would have worked and would have earned much more than 15,000 per annum. Each case has to be decided on its own evidence, but taking notional income of rupees 15,000 per annum is not at all justified. The appellant has placed before us material to show the minimum wages payable to a skilled worker such and such. In our opinion, this would be the minimum amount which she would have earned on becoming a major, adding 40% for the future prospect. It works to be rupees such and such per month in rupees, that is rupees such and such per annum. Applying the multiplier of 18, it works out to the rupees such and such, which is around of rupees such and such. Though the claimant would have been entitled to separate attendant charges for the period of during which she was hospitalized, we are refraining from awarding the same because we are going to award her attendant charges for life. At the same time, we are clearly of the view that the tortfeasor cannot take benefit of gratuitous service rendered by the family members when the small girl was taken to PGI Chandigarh and was in our village. Two, three family members.
What are you referring here?
My lord, I am referring.
What the principle you referring here?
My lord, here in this case.
Notional income.
No. I am referring how a calculation has to be made. My lord, the 40% is to be taken into consideration. The landed tribunal has not do so. The income which was at the time of accident, that has to be taken into consideration. The tribunal below difference on the basis of difference amount has been calculated. My lord, the principal law is different in awarding just compensation.
It is different in different cases.
My lord, in this case, your lordships will find
What the principle you are referring here?
The victim himself is a family person. That has been referred in the affidavit and examination chief also. Your lordships will find victim consisted two daughter's wife and himself. Entire family member has been suffering. My lord, for in reducing the income of the victim. In reducing the income of the victim, my lord. And against that, no such cost examination is there. Whether
What
victim
reduction? What is
reducing
the what reduction? What is the income? Present. What is the present income? Where is the document of 60,000?
present income, my lord, at the cost, my lord, he has been admitted. At
Where
the
is
cost,
the document of 60,000? You have only stated that this is my income. That will be taken.
my lord, at the time of putting cross examination, not a
They
single
don't
question has
have
been
to.
not a single question has been.
So if one person came that say my income is 1 crore and no cross examination done, then that has to be taken. This
My
is
lord,
the law.
in our high court, one case is there. My lord, one case is there. It is the art of the cross examination. For that is in our division bench has taken 6,000. My lord, income, notional income has assessed 6,000 notional income. On that ground,
In the cross examination, your income has been denied. That is sufficient.
my lord, that for that is a our High Court had, my lord, held in this case, in Sobita Manna's case. I think Sobita Manna.
You
I think,
stated-
yeah, I think, my lord, that the decision has been deferred before your lordship during this passage of time.
Yes. You have, you
And
you take it from me that you have not referred a single document. You have not exhibited a single income proof document. You have only stated in the chief and the claim application that I have an income of rupees 1,50,000.
yeah,
Now
1,50,000.
I have the income of
My lord,
rupees.
kindly see the
No,
document.
no,
My lord,
you just heard it.
my lord.
Thereafter, you can argue or not. Okay. The view of the court, you just heard it. Otherwise, the time would be gone. You have not produced a single document. You have only stated in your chief,
My lord, may I be permitted to see the LCR?
not necessary.
My lord, may I be permitted to see the
No,
whether
you
that
just-
document, what document has been produced, my lord? I am not.
Then why you pressing?
My lord, I
You
am
have
pressing.
not, you don't have any document.
My lord,
You also don't have any document to argue.
my lord, document is already on the record. Document is
you
already
know-
on the record.
Whether you have any knowledge regarding the nature of the document.
My lord, income tax return is there. Income tax return is there. My lord, that has been produced.
I want to know from you whether you are aware what the nature of the document. in
My
the
lord,
LCR.
I am after
No,
going
no,
through,
no. I want you whether you are aware or not.
I shall have to see. I shall have
Then
to see
you are not aware.
because that document has not been.
Then you are not aware.
My lord, that document has not been, my lord, supplied to me, even though that document has not been, my lord, given by the department concerned, the certified copy also has not been given. But as per your lordship direction, my lord, the insurance company has produced document to me, but that document is not there.
All
Certified-
as per the rule, all exhibited documents
My lord,
was supplied along with the paperwork.
my lord,
All exhibited documents.
my lord, the document which has been, my lord, given by the affiliate, my lord, that document is missing. That document is missing.
All exhibited document was along with the
My lord,
copy.
all exhibited document has been given, but that document which has been filed, my lord, in the court below, in that is already on materials of record. If document has not been exhibited, that is procedural lapses. That is procedural lapses. But the
So do you want to proceed along with this procedural lapses or that lapses you want to
my
cure?
lord, I am that your lordship, I am proceeding on behalf of my client, what is already on record. What is already on record? It is not the case that document is not in the record. That document is already on record. That has been filed on that date when the examination chief has been tendered.
So you are not ready to proceed with this. You are ready to proceed with this matter as it is. Okay, proceed.
Well, because of the fact, my lord, 2001, the accident has been taken place. And now 2023. At the time of my lord accident, the age of the victim was 39 years. Already, my lord, 23 years has been lapsed. It is impossible task for us.
Impossible task for us what? The pendency of the appeal or any, what you want to say?
My lord, your lordship knows passively. I cannot say because
I don't know active or passive voice.
your lordship knows that. My lord, so pressure is there to conclude the case. Pressure is there upon us to conclude the case. I am arguing what is materials on record. I am arguing. Thereafter, up to your lordship. After all, your lordship is to decide the case.
Yes, your argument was taken note of. You want to proceed.
Because 20 years has been left. My lord, my burden is to complete the case. My
Yes. Anything?
My lord, this is also 2023. If it is, my lord, within the periphery of 5 years or 10 years, then can be, my lord, pressure is there. Upon me, pressure is there. To correct that.
But how can it be disposed of
My lord,
without those documents?
Yes.
There is no income,
My
from
lord.
present income from nothing is there.
my lord, kindly send down the.
My lord has given 7 opportunities.
Yes.
Your lordship will kindly not grant any further.
Yes.
Lordship kindly decide. Normally, my lord, we grasp at first opportunity.
My lord, yes, yes.
My lord, 7 opportunities given, all declined. Your lordship kindly.
Yes, what is your matter? What is this?
My lord, this is the same thing, my lord, how calculation has to be made.
Personal injury.
Yes, yes. Personal injury. This is all, my lord, 30% injury, etc. My lord, that has been taken to 100%. Though it is for 40%, but the impact of earning capacity is 100%.
In this case, the disability is 45%.
My lord, then my lord kindly demand it. My lord, already. My lord, yes.
You're not for manufacturing new documents.
No. What manufacturing? The document which is already on record. That document has to be. That basis, all that. If
My
time
lord,
bound,
the
my
saddest-
lord, 20 years has been elapsed. My lord,
Saddest part is.
Yes.
My lord, lordship will kindly take note of it. The saddest part, not even today, what I saw. While starting the argument, you heard my learned friend. You know, to ask.
Yes.
What does it mean? Again, it's right. But lordship, see, when you do not have the fact, when you do not know the law, start reading the paper. Allow me to finish.
I do not go to law. Okay, my lord will decide whether something is no or not. You are not to see whether I know or no. I do not know.
Even on the
Very.
complete of your lordship, the liability and the speed for custody. Even today, the second level of this. So the demand. And what is taking my lordship? Your lordship,
That has been done. That has been done.
but let me finish the answer.
Yeah, that is done. No more how the yes,
It is so unfortunate.
yes.
Okay.
When you are arguing on the last occasion, I never single what has been told.
Okay, very well.
Submitted, anything. And you are insulting me that I do not know anything. You will be my teacher. Teacher.
No, that is not the way. What is necessary for this? Not necessary.
I am not your teacher. Inside that. I have seen several times. Used to use such type of thing. The division is also.
Yes.
I'm not sure. But the lordship will take on. This product. reflect this in my notes.
My lord, your lordship is taking for proper application of the case.
Very well.
Proper application.
Okay. Very,
For judgment.
okay. Very well. You don't have to argue. I have heard the matter. Please take down. Yes.
We have no problem. The actual outcome become
The instant appeal is preferred against the judgment dated 5th of December 2011 passed by the learned judge, Motor Accident Claim Tribunal, 5th Fast Track Court, Barasat, North 24 Parganas, in MSC case number 122 of 2004. Stop. The insurance company has preferred this appeal against the judgment passed by the learned tribunal, wherein a huge sum of compensation, huge sum amounting to rupees 40,03,000 with interest of rupees 9% per annum was awarded in favor of the claimant without any specific document of income proof. Stop. It is the case of the claimant that the initially before the accident, the claimant was engaged in Singapore, and after such accident his income was diminished. Thus the learned tribunal has assessed the compensation on the balance amount of rupees 50,000 per month. It appears from the record that the document of income was not proved or tendered before the learned tribunal. Stop. However, the insurance company has argued at length regarding the error caused by the learned tribunal. Considering the entire aspect, it appears to me that some documents of income was filed along with the examination in chief of the claimant, but these were not tendered. Stop. In that circumstances, in the instant case, the claimant would be at peril if the instant case was dismissed. though the merit of the appeal is referred so. However, the MV Act is a beneficial legislation, and it appears that the injury suffered by the claimant in the road traffic accident. Considering the same, I am not dismissing the instant appeal on merit. However, I am remanding back the same to the learned tribunal with a specific direction that the claimants are at liberty to prove the documents whatever they wanted to prove, which are already on the record. Stop. No other extraneous document has to be filed by the claimant. Stop. The claimant is further directed to appear before the government hospital, appear before the RGK Medical College and Hospital, to have his report, have a present report of disablement. The disability certificate issued by the RGK Medical College Hospital is to be considered by the tribunal afresh. Stop. The tribunal, as it is at liberty to decide the matter again, on the basis of the observation made above. Stop. The claimant claimant is at liberty to tender those documents which are already on the record, and the insurance company is also at liberty to cross-examine or to file any oral or documentary evidence as they wish. Stop. I make it clear that the claimants are personally appeared before this court, for which I think is necessary. They need be treated, they need be examined by the board of doctors to verify their percentage of disability. According to the instant appeal is disposed of, the insurance company, the insurance company is at liberty to withdraw the deposit already made, enter deposit along with the accrued interest, Connected can applications, if any, are also disposed of. Time. Okay. Again, the last. It appears that the instant accident happened in the year 2001. 2001 and 2001. Yes, 26/1/2001. 2001. Already 22 years has elapsed. Thus, the learned tribunal is directed to dispose of the matter according to the direction given above, as early as possible, most preferably within 4 months from the date of passing of the short stop. The LCR from the date. I am passing the yes. So when we will be able to appear before the learned tribunal? Yes. No. You have to appear along with all your documents. Otherwise document. Yes, on document. I directed to dispose of. Yes, they would pass the just compensation. It is not necessary. The tribunals are there for awarding just compensation. What is the further? What wants further? So, as early as possible, most preferably within 4 months from the date of filing specific application of the claimant along with the required document. Okay, required document. Okay.
And dismiss the case if we found no value. They are not giving like that. This is what solution is being given.
Next. Very well, not today. Item number 8. You are for the claimant. So what is your submission? Today Mr. Pahadi has not come. So tomorrow? Tomorrow? Good. Not today.
Point of interest is only our data. Our was passed by the time. Other after that is for that other not other details I have changed other somehow that was other detective not other detective and being studying but idea other was learning advocate and other deeply also that for marketing. Now other
So there are no claim.
now after this society can that is for his father. That mother grandmother once died. That mother
Let it be go out of list thereafter. Okay. Please take down. The matter is not ready for hearing. So the matter go out of list. What is at liberty to mention?
But the scholarship I did not get it. I have made that the appointment not. I think not market stack.
This is item number
30.
30. Okay.
National personally also informed the after
Okay. An accommodation is sought for on behalf of the appellant. Accommodation matter is urgent today. List the matter on 24th of August. You inform. Okay. Then London advocate appearing on behalf of the Oriental Insurance Company Limited. Oriental Insurance Company Limited. Miss submits that she cannot proceed with this appeal on behalf of the insurance company on her personal ground. Accordingly, stop. Personal ground. Stop. That was it. 24. কি করে দাও? 24. তো থাকলে সেখানে আপনি এখানে থাকলে কেউ করা যাবে হুম তাহলে কি নামবো নাকি একটু নামবো নাকি সার্ভারটা উঠে after 40 বাজে কাজ server is down. Display is off. Yes, 14. Yes. No, no, I will take it. No issue. I have something. Please come. Both you are very well. Deepin? Yes. 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 Hmm.
Yes.
One of the options.
Tractors.
That.
Yes.
The accident.
NRS.
Data is that. Right.
So why your claim petition was rejected?
Take down that we take the accident. Rather, they make the accident, not the accident. On the road ground. That must be not in. And on the same occasion, whether we observe that the case for activity quantum compensation because most of these advantage. Most of the employment is that show manner is for activation quantum. Other meaning manner for three quantum.
Yes.
Or the accident or the time. And on the young of the incident of money. Other well, if appointed by the mother, just and he put and find it. What are the I am other character. That mother David and only one mother David. Five minus that was and all three minor insurance company. One is first. Yeah. Whether can be minor is not the judgment.
You place the judgment first. Yes.
On 29 March. And all that is
Yes. Not necessary. It's number 2 to 6. Yes.
mishap.
That's right. One are actually time tasks, or other the findings and observations that was another one side and say that why was loading the other detector. It was the employee of the owner of the doctor. In course of employment, other the accident was formed.
Yes.
So, the course of employment, other the accident occurred. So, it is a weak case to approach another one. And in other my cases, that the P2 and P2 says that why was by not one economy. That tractor is rather the side. Putting tractor or dashing by the tractor. Opening tractor is rather the both sides. Force of employment or dashing by the tractor. Other thing, father, may I submit that you become like one the option of or you can but other key boost other other the compensation was assessed as per the following that but liability of the insurance company on is other the workman company. Supposing by law the compensation was assessed as under 5. Other as per of the workman employee compensation act, the other the compensation whole lakh is paid by the insurance company and remaining 1 lakh is paid by the owner. If it is not either received by the loss or I could by the also stated that the option of either as both or the compensation payable by the and the compensation was by not was as condition of work. But by the it is one side. It is the by the case of the insurance company because investigator under 5 report he says that why he was loading the by the tractor till now. And investigator is by the representative of the insurance company, just appointed by the insurance company. He says that due to the accident, mother sustained why it was tractor. It's clear from this. So, in course of employment, mother, if it is done, also mother is that the person what sustained into course of employment so that compensation. motor vehicle. It is one side. The other my
No,
side.
no, what is your submission? Submission is that if it appears that the person suffered accident who is entitled to have the compensation under the Workman Compensation Act, he can proceed to the tribunal of the MV Act to get the compensation.
Father, yes, tribunal can award, but tribunal ought to have assess liability, whether assess the liability, pay compensation. Upon the insurance company as per the whether.
No, what? No. No. The system is that when both the when the accident comes in both the offenses, in both the sections, then you can choose either one. This is the law. 157.
167.
167 is the law. This is the law. When it comes under both the provision, you can choose any of those, any of the four. This is the law, but your submission is otherwise. Your submission is if the person is entitled according to the Workman Compensation Act, whether he can proceed apart from the Workman Compensation Act to the Motor Vehicles Tribunal to get the compensation according to the Workman Compensation Act. No. Is that just I want to know? This is your submission.
No, this is not submission.
Then?
Father, this is tribunal minor observation is that.
No. You have read. You have read out. You have read out.
When division is filed, so one can but not
Yes.
that part is no. Other the payment subject in terms of accident can be further modified. Here my plan is both for the tribunal. So whether the tribunal of fiscal income is further as
Now, suppose one Khalasi sustained accident, Khalasi sustained accident, he may prefer Workman Compensation Act or the MV Act. But in this case, there is no involvement of any motor accident. This is the observation of Learned Tribunal.
no involvement of the vehicle.
No motor vehicle, no involvement of the motor vehicle.
Motor
Only at the landslide is there like that. Some evidence is there like landslide.
As per the investigation report, the accident is nature why it was get
It is better to read out the matter. It is better to read out the evidence.
kindly explain that. Is that the accident is not a motor accident? The accident why he was
During employment.
employment.
Yes.
Why he was loading the part? So tractor here, he was the employee of that tractor. Something different by the things. So not the tractor, it was the Kisha. Pain at the Kisha. That part father has not father died out there, not about. And in this blind case, totally by the different from the case. Then by case is that he was walking on his way and the tractor dashed him. And as a consequence, he fell down on the Amar by the 30 feet by the 50 feet by the pitch of that from portion of that market. And as a consequence, he got that portion and then he was further hospital. Thereafter, hospital. Thereafter, hospital. And thereafter, he was Father Rane tried to doubt it. Father, that no medical treatments are Another the investigative process and also annexing matter some medical paper of the matter I investigate data and now I also collect medical paper. So medical papers is equal tribunal. Other key was rather working. He was based other either by not not by not or not and not seen by the medical paper. Which were by put by the other here is rather that seems rather that sufficient material on the compensation. How the tribunal start everything. It also maybe cannot be also identity. Doctor that's it. Yes. And PW I by the identity of the accident and this is the manner of having of the accident. Tribunal basically further PW will be able details, charge sheet, postmortem report, everything. And on the basis of the investigator report, whether the tribunal hold that it is a case of some matters doubt because it decided question of the investigation and question of PW1, PW2 are not consistent. PW1 and report. I'm admitting that there is some delay in data, but this is not delay logic is not handled by the other so I'm also see the application other paragraph the hologram will case of my paper.
I'm seeing everything. You just read out.
You logic kindly see the application
Yes.
Beside other case
Yes.
application hologram
Yes.
other any other information that or is of the date of accident that is and to public and we make the kind of public other and different and he was born and last he was everything was minority. Now other you lost time to come to stand up so that is color start from what
Yes.
other kind whether paragraph 2 of the pattern get it that whether each will not see the accident but see then the accident offer on that the office that the accident offer I am fine with that copy of that draft. I hard that document. My husband will come. So Mala was directed Mala everything. So
Yes.
Mala, she was not the IT. Mala last last week you were not trying to see Mala evidence of Mala the IT. The IT is of Canada T. So all the accidents that all the gate of accidents I was some of them that's all. How Mother may I how the mother the diagram state of the mother they are thinking of system cycle of the application and the of mother the decide column number 24 of the prima application are very much confident in the effect of also wait mother if I also if you not see one go mother if I had also seen BQ was sees and the mother Chashi also sees everything there, but on the basis mother I have got the mother that the mother the evidence of mother is cannot be down the mother to respect
Come on Friday?
Friday.
Yes, tomorrow morning. Yes, very. I'm fixing her tomorrow.
My Lord,
As a first matter.
is that I Father, he said that I will do this better. Father, I have.
Yes, we are here.
I have worked out the difficulty. And tomorrow if he is not come, I already again
You are ready. Very well. We have the times constant and today is a Thursday, you know, the criminal matter.
I prayed before your Lordship.
Yes. Tomorrow. Tomorrow hold it. No second appeal is pending. Finish. Yes. Tomorrow hold it. Already after 3, I have some division bench. After 3. Okay. Okay. ঠিক আছে। Then call the list. ওটা দেখে নেবো কি চাইছেন আপনি। আমি তো শুনে নিয়েছি রেকর্ড, আপনার তো শোনানি হয়ে গেছে। রিটিন আর্গুমেন্ট, রিটিন আর্গুমেন্ট কিছু বুঝতে পারলাম না। আজকে তো আপনার ডেট নেই, আজকে কিসের ডেট আছে? আপনি মেনশনিং করতে চাইছেন কিছু? মেনশনিং আজকে আপনার তো ডিসপোজাল, আপনার তো সিএবি চলে গেছে, মেনশনিং হবে কি করে? মেনশনিং নেব না, ওটা মেনশনিং হবে না। আপনার সিএবি হয়ে গেলে আর মেনশনিং কি হবে? একটা অর্ডারের উপর আপনি রিভিশন যেতে পারেন, বাইরে কোথাও সুপ্রিম কোর্ট যেতে পারেন। আপনি যদি অর্ডারে কিছু অ্যাগ্রিভড হন তাহলে আপনি আপার ফোরামে যেতে পারেন। যদি আমার অর্ডারে কোনো অ্যাগ্রিভড হন, আপনি আমার অর্ডারে লেখা আছে আপনি পেয়েছেন ডকুমেন্ট গুলো, সেইটার জন্য বলছেন তো? ক্র্যান ফাইলে থাকবে না এইভাবে, সিএবির পরে ক্র্যান ফাইল হয়। কেস রেকর্ডিং এ ক্র্যান রেখে কি হবে? ক্র্যান হিয়ারিং হবে না, হবে না। আপনি জাজমেন্টের ডেটে আসবেন, তখন দেখবো আমি, ঠিক আছে? কালকে আসুন, কালকে দিন কপি দিয়ে দেবেন। ইয়েস, yes.
And subsequently, sanction is granted. As per the decision of the Honorable Supreme Court, I think they are addicted of it. Facts in addition to the facts which were earlier missing, and the grant of sanction was. But there cannot be any review of the order issued to grant. On this front, we have submitted certain documents.
Yes.
The other point that my knowledge is are the input document. While the execution of the application and the state where the proceeding is proceeding. Where we have taken the judgment of the own. Without any, but the state would have a very categorical and after the getting any state, they regard of the proceeding, including the order taking.
Can be.
My other friend has also got able to have the judgment in his regard, but we are finding a reply to having applicability of those judgments. We are saying that we are explaining not in our right, that those judgments are inapplicable. So I have
in respect of some judgments,
I have I learned this. Hello.
no, it can be going like that. Yes, yes. Issue is that I have no determination now, the criminal matters. I have the civil appellate claim appeal jurisdiction is now. Parted matter, so it can be Wednesday. Wednesday 2 p.m. Yes. If you want to contradict or file any judgment, you just file sub copy. Yeah, okay. 2 p.m. Wednesday ache. Their fixed matters is there. Ki kon matter? Okay. Sierra 27. Okay. Tuesday. 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 Okay, Tuesday. Tuesday at 2 p.m. Please take down. Yes. No, no. Reply of defense to the judgment cited on behalf of the CBI, filed by the petitioner is taken on record. Learned advocate appearing on behalf of the CBI wanted to file some more judgments. Accordingly, the matter is fixed on August 9th, 8th, August 8th at 2 p.m. Yes. Petition. Item number 55, CRR 3718, that is Messrs. Blue Star Limited and others. And 56, item number 56 also different complaint. And 57, that is Blue Star Ice Construction. 57, you are there. Very good. Yes. Yes.
Here, transaction, in terms of which, because in fact he has certain things which are said he has made the value. Now, of March 2006 was but thereafter there has been however, it's some circumstances of now, evaluation we have been making without finding the benefit of the additional discount which according to we have given discount towards there were certain additional discounts which and RAB and RB. These are for the different receivables against the services that we provide. This according to him is 6 lakh 50, and therefore according to him he has a view of around 1.69 lakhs. This termination has been done giving this amount of this according to the specific 10 years of question is whether for this long-term business when he has taken whatever whether the final settlement of accounts as per his version. In our version, we have to see in this version, after the final information of all the settling of all the accounts, he is supposed to get 40 lakhs or 40.69. Question is whether that can rise to a charge of whether it can be put and prompt the inception of the transaction. Prior to the 5th of March 2006, when he was appointed, these accused persons had the intention to
Yes.
2006. This in a nutshell is with the prosecution. Now, can you permit me to take your lordship? Well, that's at least 31.
Yes.
That all the petitioners are there except one. All payment.
All 10.
All 10. Now, only one thing I would like to point it out. The petitioner number 1 was appointed as a director on 1st of July 2010. And in order to make out the charge as a corporate, they have to show from the inception. The inception is 5th of March 2006. Three of the directors were appointed much after 2006. Petitioner number 4 was appointed on 1st of July 2010. Then petitioner number 5 was appointed on 13th of May 2013. That's after 7 years. And petitioner number 7 was appointed as a director on 30th of March 2000.
Okay. Yes.
Under ruling 96, date of occurrence. So they also accept that it is since March 2006 till date. It is being filed in 2007. That your complaint is the proprietor of Ramsey. The said concern and has been running the same. Then paragraph 2 then sometime on 5th of March 2006, payment was bestowed by the accused company. They mentioned that the accused number one is a company and having this accused number two is the chairman, accused number four is the managing director, accused number five is the vice president, and accused 6 to 10 are the directors of the video verification entered into 5 and 15 of completed 10 accused company for sales and service items and was thereby acquitted as and was thereby acquitted and from time to time the period of the said agreement was extended and the business was going on smoothly because of outstanding performance by the complainant for which she was appointed by the that however with some oblique motive on 26th of February 2016 a mail was sent by the accused company expressing the fact that the accused company had terminated with the complainant in complete violation of clause 15 of the agreement. In that clause 15.1 of the agreement states that the agreement shall continue until either party terminates it by giving 30 days notice in writing to the other. But no such notice was served upon the complainant by the accused company before terminating. We mentioned here that such mail was received by the complainant in the midst of a discussion with the representatives of the accused company regarding pending in respect of additional discount to the only RAB and RPD of rupees 0.459 lakhs, totaling 40.69, 40 lakhs 69,900. That at the time of execution of this agreement in the year 2006, the complainant used to get a lump sum amount towards warranty claim against the sale of each unit of product of the accused company, RAD and RPD products. But subsequently, on 12th of December 2008, the said terminology was changed and renamed as additional discount, which the complainant was supposed to receive from the accused company against the sale of each unit of various products of the accused company. That on assurance by the accused company that such additional discount would be paid at the end of the year. Complainant continued to contract with the accused company and various products of the accused company. That for the year 2011-2012, a huge sum got accepted in favor of the complainant with additional discount and on demand the accused assured the complainant that such amount would be paid for deferred payment citing various technicalities. Because of that dialectic tactics, a sum of 40.69 lakhs would be payable by the accused company for additional discount and arbitrary. The complainant was shocked to receive mail of termination of the agreement as the shop of rupees 40.69. That your complainant states and submits that he entered into the agreement with the accused only of the assurance that additional discount will be paid to the company against the sale of the unit of and had the complainant known that they would not pay such discount, the complainant would have never entered into and extended the period of the various communications were made by the complainant before it. Here, that the accused person so this is the whole case. This case is that he has been terminated, but he has some views which are exploring from 2011-12, and when at the time of 2016, when it was terminated, he was not paid his. Question arises whether it takes up the case under section. Now, the statement on following information is page 35.
The form of examination in chief. Civil action come into play.
The recording by the learned magistrate is at page 10.
Yes.
For a statement or affidavit, is a virtual replica of the document. Yes, virtual. It kindly picks up at page 40.
Yes.
Order issuing process. Order dated 6th of September 2007, page 40.
Yes.
Number 3, second. Our learned advocate for the complainant produced the complaint and the statement of witness as well as other materials of record. As such, and like
What's the address of the accused person?
claim does not disclose anything. It says about the address of the complaint at 7 years. In our applications, we have disclosed our different addresses around beyond the threshold. In West. But now, if I may take your note, page 43. The letter by me on the
15.
2015. He asks for change. It is 4. Only sales only, instead of sales and service.
Yes.
Now, before he starts the case, we are issuing the that is at page 45. This was addressed to the company.
Yes.
They have placed it from 46. That my client above me on this distributor of limited company, thereby actually That item. That all those paragraph 16 of the said exhibit as stated above. Once in a blue, an email was sent on Friday to bring. That means it's a email. Mr. G. on Saruti regarding my client's. Now, 34 lakhs, along with some. Client will be proposed to be suspended. Client respect complete. Taylor. And the email made my client known as to. Agreement copy. That my client went on RT. Last week on 17th of September 2015, some claim was settled. Even in 2015, part of this claim. That is, all defective unit or safe return or defective updated but no machine is. Reimbursement of cost of completion 2015. Quantity discount of quarter one. But the additional discount of the period 2011, 12, 12, 13, 2014, 15 towards 6,821 pieces amounting to 30.16 lakhs and 717 pieces amounting to 40 lakhs. RTD remains unsettled. Now here he does not base that. He just fixes himself to 6 lakhs to 40 lakhs. Here is now just deposit. When my clients take on business and distribution, he has retained. I therefore on behalf of my client request SP for my client has distributed to retailer also to settle the claim of my client. Enclosed dealing with my client will constrain. Then the reply of the picture of the one company that page 49.
Yes.
From the third paragraph, we make it clear, very clear that you are paying based on the action. 34 lakhs direct from any capital. Not liable for it. Further, we confirm what is the claims made by your client with additional discounts in line with was already paid and this further authenticated by a confirmation of balance dated 30th of September 2015 from client Mr. Bill building will further make it clear that by a written request dated 24th of February 2016, your compliant has been made a sale to be either within cancellation court. Hence, we are not responsible for such declaration. We are not therefore for the appropriate we are not liable. This was our right.
Got it. What is this?
This shows that even after that he continues business and in fact he has ordered foods. But that I don't think is much. Your Lordship is not even that. The question arises whether on the materials on record and as alleged in the petition of complaint, whether it is under section.
Now, what about the other cases? Other complaints?
Or the other one.
Yes.
Same. Similar type, where there is a long-standing relationship, sir, Here, there was more. He alleges that he had certain views which were tabled by the company. He required certain articles for his job work with another company. So, the company had assured him that they would supply the goods to him. The value of the goods would be adjusted against his views. However, the company had supplied him goods, but has not set it off against his claims, his receivables against the company, and instead has billed it with the amount of the value of the goods which were supplied as per his requisition. And then, according to him, this amounts to cheap. And we had, in fact, and we have utilized the checks which were lying with us, and we have initiated 128 proceedings against him.
Okay.
160. That's it. Second. But in this case, you have to consider whether it makes out the case under movement. Which part? We have prepared a.
Yes, you.
I will not copy your worship most of them. Well, if your worship permits me, the first, second, third, fourth, fifth. First, 4, 5, 6. These first 6 judgments are on the issue that where there has been part payments made against services rendered, there is an allegation that for the remainder of the services non-payment is made, that does not make out the case. These are the first 6. With regard to the other 3, is with regard to vicarious liability. There is no argument against any of the petitioner's numbers to be paid.
Sunil Bharti Mittal is there.
Sunil Bharti Mittal,
Alter ego.
yes, yes. So, in fact, there, in paragraph 48, there it was held that for the liability of for the criminal acts of the officers, the company can be made liable. But for the offences committed by the government,
Yes.
you cannot make the, and there that division was, or that distinction was made. In fact, I think it was paragraph 41. Page 94.
Yes.
The abundance clear from the above that the principle is data is to the effect that the extent of the company, that is the personal group of persons that guide the business. Take the company corporation. The legal proposition that is laid down in the opposite judgment in their case is that if the person or group of persons who control the affairs of the company committed offences with criminal intent, their criminality can be imputed to the company.
Yes.
Their criminality can be imputed to the company as well, as they are alter ego to the company. In the present case, however, this principle is applied in an extremely exactly reverse event. Here, company is the accused person. And the learned special magistrate has observed in the order that since the evidence represents the directing mind and will of each company, their state of mind is the state of mind of the company. And therefore, on this premise, acts of the company are attributed and imputed to their captains. it is difficult to accept it as the correct principle.
Yes.
As demonstrated hereafter, this proposition would run contrary to the principle of vicarious liability, detailing the circumstances under which a director. So, if we let us assume the managing director, while discharging his duties, commits an offense, it is personally liable. That perhaps as an alter ego of the company can be imputed to the company, but the reverse cannot be. That if the
Company committed an offense.
if the company is the primary offender, then it cannot be imputed
Yes.
to its office.
That
Here is the case. Well, here is the case when company is alleged to be the person who has not paid. And he imputes the liability on the petitioner's numbers to get.
yes.
But there is no above in the even signifying as to how these petitioners acted in poverty in order to commit.
Very well.
Discussion. Parents, the application of
Yes.
Lordship Thakur's committee and subject to extensive discussion into merits probably should not be allowed where the application of the final committee. Because when a court is exercising its powers under section 42, it is only to see whether a case has been made out or not, but not put into the merits. Now, in this application, I would actually agree with part of their contention. More specifically, the contention that the applicants have raised in paragraph 4. So, if I read along read of the paragraph. Paragraph 4 stating the petition of complaint vividly shows that all the accused persons in the company are situated outside the territorial jurisdiction of the learned trial. Section 202 of the Code of mandates that the learned magistrate shall in the case where the accused is residing at a place beyond the area he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case itself or direct an investigation to be made by the police. And probably the rest of the section is set up. But stunningly, no inquiry in terms of section 202 of the CRPC was ever directed and process was issued behind the civil law of the land, which indeed is a gross abuse of the law. Your Lordship, I completely agree with this. There has been a stark deviation from the settled proposition of law, and the learned magistrate should not have deviated from that section. It should have done the inquiry. However, based on that, petitioners can't go into very satisfying history. They have an alternate remedy over there, and my argument will be in line with what the Honorable Supreme Court has categorically laid out in multiple sectors. One of them being, Your Lordship, National Bank of Oman. The citation is 2013 volume. Supreme Court cases 480. Your Lordship, this judgment also deals with this scenario where compliance under section 202 was not complied. Your Lordship kindly comes to para number 11. More specifically, Lordship, if I may allow.
Yes.
All the same, the High Court, instead of quashing the complaint, should have directed the magistrate to pass fresh orders following the provisions of section 202 CRS. Hence, we remit the matter to the magistrate for passing fresh orders, uninfluenced by the prima facie conclusion reached by the High Court. And then it goes on to speak of the factual plan. Your Lordship, in another judgment, in the same line, Your Lordship, volume year 2006, volume 9, Supreme Court case 6. Lordship, it is a very short order. However, paragraph 3 and 4 are of extremely importance. Having perused the material placed before us, we are satisfied that no objection can be taken to the order of the High Court, quashing the order dated 37/2005. But there is no justification for quashing the criminal complaint itself. If the magistrate had not followed the procedure and failed to apply his mind as required by law, the order issuing process could be quashed. But the magistrate should be directed to reconsider the matter and pass fresh orders in accordance with law. So the contention, judgments which the Supreme Court has laid down categorically executed such attempts which have been made by the appellants hearing, whereby under the guard of non-compliance of section 102, along with some points on merits, they are intending to quash this case. Your Lordship, such a player can even if I rely not there in the merits. However, the Honorable Supreme Court has also stated that 482 is not the forum where points on merits can be appealed. And even if this matter is limited back to the trial, as has been stated by the Honorable Supreme Court of India, the applicants will not be answered in any manner. Their interest will not be happy. In fact, they will have a fresh start to this and they can achieve the points over there. So my short submission will be that since there has been a verification of section 200, kindly limits like this matter as has been discussed by the.
Very well, the petitioner has argued on the merit. So
Yes, Your
do you have any argument on the merit?
So, Lordship, as far as the argument is concerned, Lordship, the primary thing that the case hinges upon is the word discount. Now, Your Lordship, discount is particularly a thing.
Where is the ingredients of section 415? This is the part. 415.
Your Lordship, I try to satisfy your Lordship.
Yes.
The thing is that, in my humble opinion, the theory of part payment is extensive.
Yes.
Because this contention that a part payment will lift any sort of criminal liability from the accused is grossly wrong. Today, although this theory was instituted to safeguard the interest of innocent people, today, accused persons with utmost malice are now harping on this point to shy away from their actual liability. In this case also, Your Lordship, irrespective of what has happened, a money is due. Now, if that is the nature, if that money has been due prior to all the debtors and it has been due, the company has not paid. If I had been aware of this idea of this notion that there might come a point where I have to face this, obviously I would not have engaged with them. The fact that the company has advertised their discounts in order to lure me to engaging with them creates enough inducement. So they cannot have a blanket shield on their own action just because they have made a part payment. Because nowadays every accused makes a policy sum of part payment and then they can see we have made a part payment 420 or will not like it. That cannot be enough. However, your Lordship with utmost humility at this point, and in this jurisdiction also, I don't want to go into the merits. However, my argument is simple that since there already exists a very infirmity and application of that law, kindly limits this matter back to the trial court so that this defect can be. They can agitate their points over there as well, and if the court is fit, they will be active. It's my only sir.
Very well.
But he says that. That I did not even survey all that. Let's see.
Yes.
Before I could not come. But he said, but very. The general online one order report of 20. Then that the vacuum of the procedure with no offenses made out from the itself, then failure to comply with 202, which is to the benefit of the and the accused does not raise at the time of final hearing prejudice caused by non-compliance of the verdict. Then in those circumstances, you can go into the merits. And if he finds that no cases at all made up, then wash the. I'll provide the judgment when I take out the copy and I'll provide it to the counsel. Now, other issue that he has said that the court, Supreme Court has said without going to Supreme Court has said just because there is some error in the procedural aspect, it should not be washed. Not be washed.
Yes.
If it is without merit, then in those circumstances, that order of that judgment of the Supreme Court does not stand. Well, that is for a reply over it. I have not made any additional something. In regard to the judgment, you can that's a judgment of a coordinate bench of the Hon'ble. If your lordship agrees to it, then fine. Otherwise, if your lordship does not refer upon afterwards, there cannot be any dispute with regard to that judgment. Because the exact that judgment was referred to the National Bank of Oman. I appeared for the petitioner for the accused. The oil Bhattacharya appeared for the other side.
Yes.
And there, that contention as to the fact of non-compliance was dealt with by Madam Justice. So, like.
Yes, that is the rule. Yes, that is the rule. No issue. So all the three matter heard? Okay, first matter. Only first matter can be disposed of.
Yes. All right. So, I have got I need to be 57. I have got 57. But my critical is well, my critical is that I can also and my
The issue is that when we are concluding item number 55, the only interim order is there in the 55. For that, the 56 and 57 is going without any order, as the both the three matters are tagged together. So I am the okay, very good.
But you can keep it text week. I don't think I will pause it.
Yes, every Thursday.
Yeah, understood that authentic. My application, I understand. And the order is this matter. One extremely.
That is the.
Six if we fix. I will start.
Every Thursday.
Thursday. Because I look in the law code is there. So I am sure I understand my on the 17th.
17th.
On that day, whether it is understood that my learned, we neither of us will pay for it. Because we are not explaining for.
Very good.
I also want to get it out there. I need to be like here for that. I come, but I come because there is a plan for it. And if you want.
So it is beneficial for us.
No, my only thing is that that's not my supposition is that I have wanted visa, I have to go to July. You have all the
Okay.
and the visa will expire.
Then we must conclude on 17th. Please take down. Heard the learned advocate for the parties at length. Argument concluded made theory. Is item number 55, 56 and 57. The order call. The matter is adjourned today. Let the matter fixed on 17th. 17th of August. 55 C. 55 C.
We are just taking out the print of that just.
Yes. You are. So what can be done? Not 2 minutes next Thursday. No, issue is that they have to proceed the argument. They have to communicate. I have heard you. I have heard you all the matters. Let them conclude. Thereafter, I will pass over. I have released all my matters, FMS, first half matters. That's why it is not possible to sit. Very well. Come on Thursday. I am fixing on Thursday, next Thursday. If you not available, I will. So what you 17th? 17th. Very well. 17th. If interim order is there, give me the papers. Papers. (25th of August) on 17th. What are the 17th? Okay.